Welcome, Hamid, and congratulations on reaching this stage.
Thank you for this opportunity.
As our business concentrates on consumer protection and employment law, we would like to test your understanding of this area. Can you evaluate the benefits of key consumer protection laws?
Certainly, consumer protection laws are designed to safeguard consumers from unfair practices, misleading advertisements, and unsafe products. They also encourage ethical business conduct. Here are some of the most important laws and their benefits. 1. Consumer Rights Act 2015. This law protects consumers by ensuring they receive goods that are fit for purpose, of satisfactory quality, and match their description. It also gives consumers the right to refunds, repairs, or replacements. Example, if a customer buys a faulty smartphone, they can request a repair or refund under this act. 2. Trade Descriptions Act 1968. This law makes it illegal for businesses to mislead consumers about a product or service. Example, a car dealership cannot falsely claim that a used car has low mileage if it doesn't. 3. Supply of Goods and Services Act 1982 ensures that services are provided with reasonable care and skill and that goods sold match their description. 4. Consumer Protection Act 1987 holds manufacturers liable for defective products that cause harm. Example, if a kitchen appliance explodes due to a defect, the manufacturer could be sued. 5. General Product Safety Regulations 1994 requires all products to meet essential safety standards before being sold. Example, a toy manufacturer must ensure that small parts do not pose choking hazards for children.
Great explanation. Now let's talk about employment laws. How does the Employment Relations Act 2004 impact workplace relations and contract termination?
The Employment Relations Act 2004 was introduced to strengthen the rights of employees, particularly in the areas of dispute resolution and fair treatment at work. Here's how it impacts employment relations. 1. Protects employees from unfair dismissal. Employers must provide valid reason for termination and follow a fair process. 2. Encourages mediation and dispute resolution. Before an employee takes legal action, mediation through services like ACAS, advisory, conciliations, and arbitration services is encouraged. 3. Strengthens union rights. Employees have the right to be represented in negotiations and grievances. Example, if an employer fires a worker without due process, the employee can file an unfair dismissal claim under this act.
Why is it important for businesses to comply with consumer safety laws?
Consumer safety laws are essential for protecting customers and maintaining trust in the marketplace. Here is why businesses must comply. 1. Legal compliance. Failure to comply can lead to lawsuits, penalties, and product recalls. 2. Prevents harm to consumers. Businesses must ensure that products do not pose risks to users. 3. Builds brand reputation. Companies known for safe and high-quality products gain consumer trust. 4. Ensure fair competition. Prevents businesses from cutting corners on safety to save costs. Example, a toy company must comply with the General Product Safety Regulations 1994, ensuring that toys meet safety standards and do not contain toxic materials.
That makes perfect sense. Now, let's talk about company structures. Can you explain different company structures and their legal implications?
Certainly, a sole trader runs the business alone and has unlimited liability, meaning they're personally responsible for any debts. In a partnership, two or more people share profits and responsibilities, and they also share joint liability. A private limited company, Ltd., is a separate legal entity owned by shareholders, offering limited liability, which protects personal assets. A public limited company, plc, can sell shares to the public, also has limited liability, but must meet stricter financial and regulatory requirements. For example, while a freelancer operating as a sole trader takes on full personal risk, forming a limited company offers legal and financial protection.
Great, very informative. And now about contract termination. What are the legal reasons for terminating an employment contract?
1. Dismissal for misconduct. If an employee is guilty of theft, harassment, or fraud. 2. Redundancy. If the company no longer needs the role due to restructuring. 3. Resignation. When an employee voluntarily leaves, usually giving notice. 4. Mutual agreement. When both employer and employee agree to end the contract amicably.
And what laws regulate termination of employment?
Employment Rights Act 1996 protects employees from wrongful dismissal and ensures minimum notice periods. 2. Equality Act 2010 prevents discrimination-based termination. Example, firing someone due to gender, race, or disability. 3. Employment Relations Act 2004 ensures fair disciplinary procedures and dispute resolution before dismissal. Example, if a company downsizes, they must follow redundancy procedures and offer proper compensation.
Thank you. That brings us to the end of the interview. Do you have any final thoughts?
Yes, to summarize, consumer protection laws ensure fair business practices and customer rights. Employment laws protects workers and regulate fair dismissals. Company structure affects liability and financial responsibility. Contract terminations laws ensure fairness and prevent wrongful dismissals.
Thank you, Hamid. We appreciate your knowledge on these legal topics.
Thank you. I appreciate the opportunity and look forward to contributing to your firm.